In Clause 12, Amendment 34, the Baroness Morgan of Cotes.
My Lords, it's a great pleasure to rise to speak to this group and these amendments. And as it's the first time I've spoken at this stage of the Bill's proceedings, I want to declare my interest as a trustee and founder of the mental health charity, the Loughborough Wellbeing Centre, which is relevant to this particular group of amendments. And if it is lawyers' confession time, then I am going to confess to being a non-practising solicitor, but I can assure those members of the House who are not lawyers, they do not need to be lawyers or ex-lawyers to understand what is a very simple proposition at the heart of this group of amendments. So I rise to speak on Amendments 34 and 35 in my name, along with the Noble Baroness, Baroness Parminter, and the Lord Bishop of Gloucester and the Lord Griffiths of Buryport, and I'm very grateful to them for their support for these amendments. The amendments are supported by the Football Association, by Kick It Out, by Beat, by Young Minds, the Royal College of Psychiatrists, the British Psychological Society, Mind, the Mental Health Network, the NHS Confederation, Rethink Mental Illness and Mental Health UK. And I particularly want to thank the Mental Health Foundation for their support with making the points that we will cover in this group. Now, as we've already heard rightly, of course, it's difficult with a bill of this complexity just to debate one particular topic in one particular group. So we've already talked this afternoon and previously, because although I haven't spoken, it's been a great privilege to listen to your lordships on earlier groups about the government's triple shield approach and the replacement of that for the legal but harmful provisions that were taken out of the bill. And we've heard that the triple shield consists of the removal of illegal content, the takedown of material in breach of own terms of service, and we've just been talking about that, and then the provision to adults of greater choice over the content that they see online using these platforms. And it's that third, I put limb, but I've changed it because of what Baroness Fraser, my noble friend Baroness Fraser said, the third leg of the triple shield categories, that user empowerment tools should be on by default. And that's what we're talking about in this group of amendments. Now, the change that is suggested by this proposal would require users on these platforms to flip a switch, to choose if they want to opt in to some of the most dangerous content available online, rather than receiving it by default. And this adopts the government's existing approach of giving users choice over what they see, but ensures that the default is they will not be served this kind of material unless they actively choose to want to see it. Now, the new offence on encouragement to serious self-harm, which the government has committed to introducing, might form part of the solution here, but we cannot criminalise all of the legal content that treads the line between glorification and outright encouragement, and no similar power is proposed to address eating disorder content, and I know that others will talk about that, and I also want to pay tribute to the work of Vicky Ford, Member of Parliament, in relation to eating disorders, and she's been brave enough to share her own experiences of those disorders. Now, over the course of the bill's journey through Parliament, we have heard how vulnerable users often internalise the harmful and hateful content that they see online, which in turn can lead to users deliberately seeking out harmful content in an attempt to normalise self-destructive thoughts and behaviours. And we have heard how Molly Russell, for example, viewed tweets which normalised her thoughts on self-harm and suicide, and we've also heard how people with eating disorders often get what is called, in quotations, thinspiration on platforms like Tumblr, Instagram and TikTok. We know from various studies that viewing this content has a negative effect on people's mental well-being. A study carried out by the University of Oxford found that viewing images of self-harm often encouraged individuals to start self-harming, and concluded that, and I quote, "Young people who self-harm are likely to use the internet in ways that increases their risk." Research by the Samaritans also proved similar results, with 77% of respondents answering that they sometimes or often self-harmed in the same or similar ways after viewing self-harm imagery. The Mental Health Foundation, in their polling of over 3,300 people, found that 67% of the public, and I think actually my noble friend the Minister, perhaps not without referring to this research, had just said earlier that 67% of the public agreed or strongly agreed they do not wish to be exposed to harmful content unless they explicitly choose to see it. But as we've also heard from the noble Lady Baroness Marion, who's not in her place at the moment, but even if a user is not searching for harmful content, they can be led to it through the algorithms. This includes pro-suicide, pro-self-harm, pro-anorexia and pro-bulimia content. In other words, it is too easy for users to see harmful content on these platforms, and this needs to change. Now, as we've heard, the government chose to change from legal but harmful to the triple shield approach. The user empowerment tools introduced, however, are neither new nor groundbreaking, because a lot of social media platforms already claim to have filters in place, giving users the ability to hide certain content from their timelines. But many users do not know that they are there or how to properly use them. So the government's solution, as it stands, will be largely ineffective unless these tools are on by default. Another point that I suspect others will make, but we have heard in the briefings before this grouping, is that vulnerability does not stop at the age of 18. So why would there be a cliff edge that actually there is to be protection from known harmful content for those users under the age of 18, but not for those over the age of 18? As the Samaritans, as somebody made clear in the Samaritans briefing, which a number of us attended, people, of course, can be sectioned for their own protection after the age of 18. And adults, and particularly the vulnerable, may not be in a position to self-protect. And the trouble with not having the tools on by default is that we are yet again putting the burden on the vulnerable, on potential victims, to self-protect without taking responsibility for this as a society. Now, there is, of course, a wider point here, which is perhaps not for this debate, but I'm sure will come up again, which is, of course, not seeing the content doesn't mean that it doesn't exist. And we'll return to this when we debate content which is violent against women and girls. The noble Lady Fox has already referred, I think, to the content set out in subclauses 10, 11 and 12 of this clause. And, of course, just the fact that it's listed, are we saying that such harmful content is still okay to circulate on the internet just because people are not seeing it? I would say this raises broader questions, but perhaps not a debate for this afternoon. So, my Lords, these two amendments would ensure that platforms design will involve the safest options being on by default. These are two straightforward, common sense amendments that balance, as the noble Lord, who's not here now, Viscount Colville, said, the understandable concerns about freedom of speech with safety. They don't stop the publication of this objectionable material, but they do offer others, particularly the most vulnerable, a real choice about whether they see it. And I'd argue that actually it's our minimum duty to make sure these safety protections are on by default.
Assume the noble Baroness would like to move her amendment.
Thank you very much, Mr. Chairman. I would, of course, like to move these amendments. Thank you.
Amendment proposed, page 12, line 9, leave out if they wish to increase their control over, and insert to control.
My Lords, it's a pleasure to be collaborating with the noble lady, Baroness Morgan. We seem to have been briefed by the same people, been to the same meetings, drawn the same conclusions. But there are some things that are worth saying twice, and although I'll try to avoid a carbon copy of what the noble Baroness has said, I do hope that the central points will make themselves. The internet simply must be made to work for its users above all else. And that's the thrust of these two amendments that stand in our names. Through education and communication, well, it can be a powerful means of improving our lives. But the internet must always be a safe platform on which to enjoy a basic right. It can't be said often enough that to protect users online is to protect them offline. To create a strict division between the virtual and the public realms is to risk ignoring how actions online can have life and death repercussions, and that's at the heart of what these amendments seek to bring to our attention. I was first made aware of these amendments at a briefing from the Samaritans, where we got to know each other. There I heard the tragic accounts of those whose loved ones had taken their own lives due to exposure to harmful content online. I won't repeat their accounts, this is not the place to do that. But understanding only a modicum of their grief made it obvious to me that the principle of safest option by default must underline all our decision-making on this matter. I applaud the work already done by members of this House to ensure the safety of young people online. Yet it's vital, as the noble Baroness has said, that we don't create a drop-off point for future users, one in which turning 18 means sudden exposure to the most harmful content lurking online, because it's always there. Those most at risk of suicide due to exposure to harmful content age between their late teens and early 20s. In fact, a 2017 inquiry into suicides of young people found harmful content accessed online in 26% of deaths in under 20s and 13% of deaths in 20 to 24-year-olds. It's vital for us to empower users from their earliest years. In the Select Committee, where I see fellow members sitting here today, we've been looking at digital exclusion and the need for education at all levels for those using the internet and looking for good habits established in their earliest years is the right way to start. But it goes on after that, because the world that the young people go on to inhabit in adulthood is the one where they're already in control of the internet if they've had the education earlier. Adulthood comes with the freedom to choose how one expresses oneself online. Of course it does. But this must not be at the cost of their continuing freedom from the most insidious content that puts their mental health at risk. Much mention has been made of the Triple Shield, and I need not go there again. Its origins and its deficiencies, perhaps, have been mentioned already. The Centre for Countering Digital Hate has recently conducted an experiment creating new social media accounts that show interest in issues of body image and mental health. This study found that TikTok served suicide-related content to new accounts within 2.6 minutes, with eating disorder content being recommended within 8 minutes. My lords, at the very least, these disturbing statistics tell us that users should have the option to opt in to such content and not to have to suffer this harm before later opting out. While, of course, the option to filter out certain categories of content is essential, it must be toggled on by default if safety is to be our primary concern. So the principle of safest by default creates not only a less harmful environment, but one in which users are in a position to define their own online experience. The space in which we carry out our public life is increasingly located on a small number of social media platforms, those Category 1 platforms already mentioned several times, that everyone from children to pensioners use to communicate and to share their experiences. We must then ensure that the protections we benefit from offline continue online, namely protection from harm and hate that poses a threat to our physical and mental well-being. When a child steps into school or a parent into their place of work, they must be confident that those with the power to do so have created the safest possible environment for them to carry out their interactions. My lords, this basic confidence must be maintained when we log into Twitter, Instagram, TikTok, or any other social media giant.
My Lords, I rise to speak to my Amendment 43, tackling clause 12.1, which expressly says that duties in clause 12 are to empower users. And my concern is to ensure that, firstly, users are empowered, and that also legitimate criticism around, for example, the characteristics listed in sections 12.1 and 12.2 are not automatically treated as abusive or inciting hatred, as I fear they could be. And my amendment 283ZA specifies that in judging content, this is to be filtered out after a user has chosen to switch on various filters, that the providers act reasonably, that they pause and consider if they have reasonable grounds to believe the content of the kind is of the kind in question, i.e. abusive or problematic. Now, anything under the title Empower Adult Users sounds appealing. I mean, how can I oppose that? I am, after all, a fan of the taking back control form of politics, and here's a way, surely, for users to be in control. And on paper, replacing the legal but harmful clause with giving adults the opportunity to engage with controversial content if they wish through enhanced empowerment tools sounds very positive. And actually, if I could quote the noble Baroness Featherstone from an earlier discussion of the bill, she said, let's treat adults as adults, allowing them to confront ideas with, quote, the better ethics, reasoning and evidence that has been the most effective way to deal with ideas from Socrates onwards. Hear to that. However, I worry that rather than users being in control, there is a danger that the filter system might infantilise adult users and actually disempower them by hardwiring it into the bill a duty and a tendency to hide content from users. I think there's a general weakness in this bill that I've already noted that some platforms are actually based on users moderating their own sites, which I'm quite keen on, but this will be detrimentally affected by the bill, leaving those users in charge of their own moderation with no powers to decide, for example, what's in Wikipedia or other Wikimedia projects, as an example, that are added to, organised and edited by a decentralised community of users. So I'm certainly not going to take the phrase users empowerment at face value. And I'm slightly concerned about linguistic doublespeak, or at least confusion. The whole bill is being brought forward in a climate in which language is weaponised in a toxic minefield, a climate of you can't say that. And more nerve-wrackingly, words and ideas are seen as dangerous and interchangeable with violent acts in a way that I think really needs to be unpicked before we pass this legislation. Speakers can be cancelled for words deemed to threaten safety of listeners, but not physical safety, but opinions that are said to be unsafe. Opinions are treated as though they cause damage or harm as viscerally as physical aggression. So lawmakers have to recognise that the cultural context and realise that the law is going to be understood and applied in that context, not in the abstract. And I'm afraid the language in 12.1 and 12.2 show no awareness of this wider backdrop, and I think it's worryingly woolly and vague. And we've already heard Baroness Morgan talk about dangerous content, and all the time we have to ask, who is going to interpret what is dangerous? What do we mean by dangerous or harmful? So we take a term like abusive that's used in the legislation, surely that's open to wide interpretation. Dictionary definitions of abusive include words like rude, insulting, offensive, and certainly it's subjective. And so when some commentators who complain they've been victims of online abuse, and then actually if you check their timeline, you notice that actually really they've just been subject to angry and sometimes justified criticism, we have to query what we mean by the terms. I recently saw a whole thread arguing that the Labour Party's recent attack ads against the Prime Minister were an example of abusive hate speech. I'm not making a point about it. I'm asking who gets to decide. And if this is the threshold for filtering content, then I think there's a danger of institutionalising safe space echo chambers. I think it can also be a confusing word for users too, because if someone applies a user empowerment tool to protect themselves from abuse, the threshold at which the filter operates could be much lower than they intend or envisage. But by definition, the user would not know what had been filtered out in their name. And they have no control over the filtering because they never see the filtered content. And the same is true of the Bill's use of the term incites hatred. The word hatred in 2023 is actually highly contentious in the public arena. Indeed, over the last decade, Parliament has really wrestled with criminal offences in terms of incitement to hatred, and safeguards were built into legislation in the past, including free speech clauses in controversial areas such as religion. However, in this bill, the term hatred is just, it seems to me, free-floating. So a user who understands inciting hatred to cover really malicious, nasty content might not realise how much other content could be filtered out by the filtering tool if it operates at a low threshold of understanding what inciting hatred is. It's also the case that inciting hatred around protected characteristics is fraught as an issue offline, let alone online. Huge rows about whether accusations of Islamophobia and inciting hatred of Muslims is used to avoid sometimes open debate on extreme Islamist views. Or will, for example, images such as the cartoons in the Charlie Hebdo magazine be seen as inciting hatred by some? Will they get filtered out? Similarly, some say accusations of anti-Semitism inciting hatred of Jewish people is used to quell legitimate criticism of Israeli policy. And I could go on. And I'm not making a comment on any of those issues, other than to note that those who think that hatred as a basis for filtering online content is easy need to get out a bit more. And that's before we even get on to the gender wars. Regularly, those who assert the immutability of biological sex are accused of whipping up hatred against trans people. Joanna Cherry MP has just had a talk cancelled by the Stand Comedy Club for just that. And even though the label transphobic hate speech directed at Joanna Cherry MP is totally illegitimate, in my opinion, because she's a crusader for women's rights and lesbian rights, it doesn't matter whether you or I agree or we should have an argument or whatever. That's what debate is. But we have to ask, who will filter out or decide from a big tech company what is hatred or not? So these are the kind of issues that I think we have to take note are difficult. So it's worth noting, and I suppose I wish to ask the Minister, who does the government envisage will do the filtering? Do online filterers, let alone algorithms or machine learning, have the qualifications to establish what constitutes abuse or hatred? In other professions, from the College of Policing to overzealous HR departments and senior management teams in universities, we've seen over-caution in censoring and banning material under the auspices of hatred, of abuse, and obviously over that weasel word, harm again. So won't the bill, rather than empowering users, empower a new staff team of filterers trained in their own company's equality, diversity and inclusion norms to use filtering tools at the lowest common denominator and leading to over-removal policies that err on the side of caution in order to comply with regulations? So all that Amendment 43 does is to borrow the language of discussion or criticism from the free speech clause in the stirring up hatred offences section of the 1986 Public Order Bill to try and lift the threshold at which 12.1 and 12.11, 12, see, because I'm so confused, might kick in. It's not ideal, but there's a lot at stake. And just to finish, I just want to completely oppose those amendments which promote a default setting. That is clearly advocating a censorious approach to legal speech. I rather liked an analogy that I heard the IEA's Matthew Lesh use recently, when he said, imagine if when you go to a bookshop and you had to ask the shop assistant to let you into the special room that contains harmful books. Of course, material is still accessible, but creating a barrier to accessing certain speech that is perhaps uncomfortable in terms of religion or race or gender also forces people to identify themselves. If you say, can I please switch into the harmful speech section or go into the harmful section of the bookshop, immediately you label yourself as pro-dangerous, pro-harmful material. And to be honest, if those advocating these provisions are so certain about the righteousness of knowing this speech is problematic, then I think it would be more honest to just simply outlaw it. And what's more, the director of Defend Digital Me, Jen Person, has raised concern that by considering all adults to be at risk of harm in this way, that the bill can infantilise us because it assumes that adults are inherently vulnerable. It's a sort of paternalistic big brother that I think we want to avoid in the bill. My lords, finally, it is damaging in a democracy to have a proliferation of things that are unsayable. And as this bill reflects, so much debate takes place online. So it seems to me that it's our responsibility as legislators to encourage a diversity of views to circulate, rather than carelessly or inadvertently narrowing the range of what circulates previously. In previous groups, we've mentioned Germany's now infamous legislation which was brought in 2017, which now actually is facing major opposition at home, because a Danish free speech think tank, Justitia, notes the German government's adoption of NetzDG was a good faith initiative to curb hate online, but has provided a blueprint for internet censorship that's been used to target dissent and pluralism. And I fear that unless we're very careful with this section, we will do the same.
Lords, it's a pleasure to follow Baroness Fox. I'm afraid on this issue, as I'm sure she will expect, we rather profoundly disagree. And I am delighted to support Baroness Morgan's amendments, and indeed the amendments from my noble friend Lord Clement-Jones, which I think does the same sort of thing, which is addressing this very critical issue of what is the proportionate response, respecting that the position for adults is different to children. What is the proportionate response, recognising that there is a large cadre of vulnerable people who need help to manage this tool, this beneficial tool, but also this worrying tool, which is social media. And I rise only to cover the issues on which I have any degree of competence in this complex field, which is to speak on the issue of why this amendment is important because of the particular nature of eating disorders, and I declare my interest as a mother of a young adult who has eating disorders and had them when she was a child as well. And Baroness Fox talked about, the need to treat adults and allow them to use their reason. Well, let me tell you, for people with eating disorders, when you're adults, I'd love it if I could get my daughter to be as reasonable as she is when I can talk to her about the benefits of proportional representation, where she can beat me hands down, but I cannot get her to put food in her mouth. Eating disorders have two particular issues which are of relevance, I believe, in this debate, and why I support the case for the strongest protection, than the default being that people should have to opt in to have access to harmful content. Firstly, eating disorders are intensely controlling. They suck people in, and it's not just about not eating, it's about controlling how they exercise, it's controlling about who they see, it's a control mechanism over a whole person's life. And the idea that you could get someone who is controlled day and night by an eating disorder to make the decision to opt out of accessing social media content, when we know that people with eating disorders are gravitating towards that because it provides them with content which sustains their illness. It provides them with communities of other users, the pro-MIA and the pro-anacytes, which sound incredibly comforting, but are actually communities of people who are encouraging people sometimes literally to starve themselves to death. That controlling nature means that for me, to have people to opt in is the best way forward. So it's a controlling illness. And secondly, it's a very competitive illness. If you get an eating disorder, you want to be the thinnest if you get anorexia. Now, in the old days, it meant you cook food, but you wouldn't eat it, but you get your sister to eat it, and you'd feel good because you were thinner. Well, of course, with social media, what it now means, you can access all these websites, and you can see people with nasogastric tubes. You can see people doing much better, inverted commas, and as the noble lady Baroness Morgan said, the dreadful phrase thinspiration. That's what they look for, thinspiration, thinness. They compare themselves to other people, and it's an insatiable desire. So the idea that they are going to voluntarily opt out of that is just, away with the fairies. So as I say, I think it is about what is a proportionate response to others. I appreciate that people with eating disorders may well choose that they will choose to opt in, but I think for the state, in the first place, they should make it that you have to opt in for that choice. And we've heard about all these mental health organisations who've made the case. But for me, when I was thinking about it, and when I was talking to Rose about it, there was one other fundamental reason why I think it's right that the state should take this approach. Because as Baroness Morgan said, eating disorders, they can start in young age, but they can also start after 18. So let's say we've got someone who's in their mid-20s or their mid-30s or their mid-40s. They're starting to feel a bit uncomfortable about their body image. They're starting to get some rather odd views about food, but they haven't yet got an eating disorder. That is the time when, if they get the support and they don't get the encouragement, we might be able to stop them getting sucked into these appalling vortexes of eating disorders. They could be actually stopped. If we have this provision now that someone has to opt in, they may not see that content which was mentioned that's being, pushed at them. And I heard the Right Reverend Prelate, the Bishop of Oxford, again using examples the other week about these sites which push people. As soon as they start going down this route, they'll feed you stuff immediately. Well, if people have to opt in, we might just have that chance of stopping them getting those eating disorders. For me, that's the role of the state. Yes, people have to be given the access to some of this material in a free society, but it's the role of the state to protect the vulnerable, and the particular nature of eating disorders, for me, mean this amendment is vital.
My Lords, it's a privilege to follow Baroness Parminter in that very moving speech, and so personal. My Lords, I'm sorry I wasn't able to speak to the previous group of amendments, partly in my name, because I wasn't able to be present as that particular section of the debate began late last Tuesday because of unavoidable business in my diocese. But it's very good to be able to support this group of amendments, and I hope tangentially to say something also in favour of risk assessment, but I'm conscious that other noble lords ably made many of the points I was going to make. My Lords, in terms of this group of amendments, it's my friend the Right Reverend Prelate, the Bishop of Gloucester, has added her name in support, and I would also want to be associated with them. The Bishop of Gloucester is not able to be here today. As has been said, we're all aware that reaching the threshold of 18 does not somehow award you exponentially different discernment capabilities, nor wrap those more vulnerable teenagers in some impermeable cotton wool to protect them from harm. We are united, I think, in wanting to do all we can to make the online space feel safe and be safe for all. However, there is increasing evidence that people do not believe that it is. DCMS's own public attitudes to digital regulations survey is concerning. The most recent data shows that the number of UK adults who do not feel safe and secure online increased from 38% in November-December 21 to 45% in June-July 22. My Lords, if that trend increases, the number will soon pass half the UK adults who do not feel safe and secure online. And it's vital that we protect society's most vulnerable. When people are vulnerable through mental health or other challenges, they are surely not able to protect themselves from being exposed to damaging online content by, as we've just heard, making safe choices. So in making this an opt-in, we would save lives when people are at a point of crisis. My Lords, in listening to our debates, I sometimes feel we have not grasped in our deliberations as a committee the inequality of arms which exists in an individual faced with the entire internet. We've heard analogies this afternoon of a bookshop. We might think of a supermarket. We might think of a debate in the Athenian Agora many years ago, when people debated person to person with an equality of arms and intellect. My Lord, there is no such equality of arms when it comes to exposure to the internet and social media. If I might categorise 5 things which break this inequality down, in the first place, advertising. They all begin with A, if you like, alliteration. But the whole expertise of the advertising industry, commercially driven through applications, places itself, its weight on the individual. The accumulated skill of how to sell more to more people is focused and channeled through all of the social media that we are concerned with regularising. Second is access. Through the mobile phone in the 19-year-old's pocket and in mine, social media and the app producers have access 24/7 in the most private and intimate moments of our lives to influence and shape our minds. There is no physical boundary of going to a bookshop. It's present where we are. The third A is access to our data. The people who are pushing things at us know more about us than the closest members of our families, because they study every purchase. Every click is interpreted. Every enquiry that we search is all channeled back into access to our data and used to pressure the individual and to shape their choices in the offline world as well as the online world. Fourth, all of this information and skill is then channeled algorithmically and driven by the power of algorithms and multiplied again in ways that no one, as a consumer, fully understands or can measure. And fifthly, we are now on the threshold of so much of the content to which we and others are exposed, being absolutely energized and powered by artificial intelligence, so that the problems that we have seen to date are multiplied and will be multiplied hugely in the coming decade. My Lords, I believe that people will look back on the first 2 decades of the 21st century, the time that Lord McNally referred to from 2003, when we didn't envisage what was coming, to this bill in 2023, as a time of complete madness, when we created such harmful, toxic environments, not only for children and young people, but for adults, that it affected the mental health of a generation profoundly. This bill is an opportunity to draw a line in the sand and to remedy that. The user empowerment tools, the adult risk assessments offer us very important tools. My Lords, we must take this opportunity and fight back in this inequality of arms. I support these amendments.
My Lords, I want to contribute to this debate on the basis of my interests as laid out in the register as Chief Executive of Cerebral Palsy Scotland, my work with the Scottish Government on people with neurological conditions, and as a trustee of the Neurological Alliance of Scotland. And it's an honour to follow the Right Reverend Prelate, whose point about the inequality that people experience in the online world is well made. But I want to be clear that when I talk about ensuring online protections for people with disabilities, I do not assume that all adults with disabilities are unable to protect themselves. But evidence constantly illustrates, as the Right Reverend Prelate, the Bishop of Oxford spoke about, the Noble Lord Griffiths of Burry Port also pointed to survey after survey demonstrates how offline vulnerabilities translate into the online world. And Ofcom's own evidence suggests that people with physical disabilities, learning disabilities, people with autism, mental health issues and others can be classed as being especially vulnerable online. Now, I believe the government recognises that vulnerable groups are at a greater risk online, because in its previous incarnations, this bill included greater protections for such groups. We spoke in the previous debate about the removal of the legal but harmful parts of the bill and the imposition of the triple shield. And the question remains, from that debate and to this one, does the triple shield provide sufficient protection for these vulnerable groups? As I've said previously this afternoon, user empowerment tools are the third leg of the triple shield. But they put all the onus on users and no responsibility on the platforms to prevent individuals' exposure to harm. So amendments 36, 37, 38A, tabled by the Noble Lord in the name of Noble Lord Clement-Jones, simply seek to make the default for the proposed user empowerment tools to be on. Now, I don't pretend to understand how technically this will happen, but it clearly can happen because the bill requires platforms to ensure this is the default position for children, to ensure protection for children. Now, the default position in amendments 36, 37, 38A protects all vulnerable people, and that's why I would support that. I'm afraid, unlike my noble friend Baroness Morgan's amendment number 34, which lists specific categories of vulnerable adults, I would prefer that actually all vulnerable people are protected from being exposed to harm in the first place. Nobody's freedom of expression is affected in any way by this default setting, but the overall impact on vulnerable individuals in the online environment will, I assure you, be significant. Nobody's ability to explore the internet or go into those strange rooms at the back of bookshops that the noble Baroness Fox was talking about will be curtailed. The government has already stated that individuals will have the capacity to seek out these tools and turn them on and off, and that these tools must be easily accessible. So individuals with capacity will be able to find the settings and set them to explore to whatever legal content they choose. But, my lords, is it not our duty to remember those who do not have capacity? Adults with a learning disability, people at a point of crisis, as Baroness Parminter, the Noble Lady Baroness Parminter so movingly explained for people with an eating disorder, who might not be able to turn to these tools due to their affected mental state, or may not realise that what they are seeing is intended to manipulate. Protecting these users from encountering such content in the first place surely tips the balance in favour of turning the tools on by default. Now, I'm very sad, my lords, that the noble lady Baroness Campbell of Surbiton cannot be here. because I think her contribution to this debate would indeed be powerful. But for her, this is her top priority of the bill. From her enormous experience of work with disabled people, this is her one thing that she wants to ensure. I mean, she wants lots of things, I'm sure, but this is her top priority. And in preparing to speak to these amendments, I looked back to the inquiry in the other place into online abuse and the experience of disabled people that was prompted by the petition by Katie Price due to the shocking abuse directed at her disabled son, Harvey. In April 2019, the government responded to that inquiry, saying it was aware of the disproportionate abuse experienced by disabled people online and the damage such abuse can have on people's lives, career and health, and the government pledged to act. The internet is a really important place for disabled people, and I urge the government to ensure that it remains a safe place for all of us and accept these amendments that would ensure the default settings are set to on.
My Lords, I rise to support the amendments in the name of the noble Baroness Morgan, and I do so somewhat reluctantly, not because I disagree with anything that she said, but because I would not necessarily start from here. So I wanted to briefly say three very quick things about that and then move on to 42 and 45, which are also in this grouping. The three things I want to say is we already have default settings. Yes, I think that we are pretending as if this is a zero-sum game, but the default settings at the moment are profiling us, filtering us, rewarding us. As the noble bishop said, Right Reverend Prelate said in his immensely powerful speech, we are not starting at zero. And so the noble Lady Fox, I do share her concerns about who gets to choose. And I do think that some of us on this side of the debate are saying, can we define who gets to choose? Can Parliament choose? Can Ofcom choose? And can we not leave it in the hands of tech companies? So on that, I fully agree. But we do have default settings already. And this is a question really of looking at some of the features as well as the content. And I do think it's a weakness of the government argument that it keeps on coming back to the content rather than the features, which are the main driver of what we see. The second thing I just wanted to briefly say is which is where I am anxious about the Triple Shield, is does not knowing you're being abused mean that you are not abused? And I say that with some considerable personal abuse. I have my filter on, I'm not on social media, but my children, my colleagues, and some of the people I work with around the world do see what is said about me, and I think that it is a reputational thing, and for some of them, a hurtful thing, and that is why I am reluctant in my support. However, I do agree with all the speakers who have said that our duty is to start with those people who are most vulnerable, and I wanted to give the words of one of the 5 rights advisors who, when invited to identify changes, redesign the internet, a 17-year-old girl, she said, couldn't we do all the kind things first and gradually get to the horrible ones? And I think that that could be a model for us in this chamber. So I do support the noble lady. I did want to move very briefly to Amendment 42, which would see an arbitrary list of protected characteristics replaced by the Equality Act 2010. And I do think this has a lot to do with a previous discussion we had about human rights. And I just really want to say urgently to the noble Lord the Minister, the offer of the Online Safety Bill is not to downgrade human rights, children's rights and UK law, but rather bring forward a smart and comprehensive regime to hold companies accountable to human rights, children's rights and UK law. And so we don't want to have a little bit of a list of some of our children's rights, or a little bit of a list of some of our legislation. We would like our legislation, our rights, embedded in the bill. And then I have to speak for Amendment 45, and I really want to express my gratitude to the Noble Lord Stevenson for bringing this forward. And it would ask Ofcom to look 6 months after the event and say, do children need these user empowerment tools? And I think that it's hugely important, because I'd like to remind the House that children not only have rights, but they have an evolving capacity to be out there in the world. And as I said earlier, the children's safety duties have a bit of a kind of cliff edge feeling to them. And actually, as they go out into the world, maybe they'd like to have some of these user empowerment tools going forward into adulthood, right on the cusp of adulthood.
Say briefly, the Noble Baroness, Lady Kidron, referenced perhaps we should begin with having particular regard for certain vulnerabilities, words to that effect. But we're dealing here with primary legislation, and this really concerns me. Lists like this in Clause 12 are really dangerous. It's not a great way to write law, because we could be with this law for a long time. I took the 2003 bill, the Communications Act, through for Her Majesty's opposition, and I can tell you that we were doing our absolute best to future-proof the legislation. There was no mention of the internet in that piece of legislation. It wasn't actually, with great respect to the Noble Lord opposite, who's McNally, because we sparred in those days. It wasn't actually that act that introduced Ofcom. That was a separate act. The internet wasn't even mentioned until the late Earl Northesk introduced an amendment with the word internet to talk about the Investigative Powers Act. The reality is we already had Facebook. We already had tremendous damage being done through Facebook to people like my daughter, who was part of it, because in the early days, if you remember, it was Oxford, Cambridge, Yale and Harvard. That's how it all began. And it was an amazing thing, but we couldn't foresee what was going to happen. But there was a real attempt to future-proof. But if you start having lists like this, Clause 12, you can't just add on. You can't just change. Cultural mores change. So this list that looks great in 2023 might look really odd in about 2027, or there'll be groups, different groups, that have emerged who say, well, what about me? What about me? And actually, also just to say to the Noble Baroness Lady Fox, I entirely agree with you. Who is going to be the decider of what is right and what is rude, what is abusive? I have real concerns with this. I do think the government has had several years to get this right. And I say that with great respect to my noble friend, the Minister. But I think we're going to have to think about some of these issues a little bit further. The design of the technology around all of this is what we should be imposing on the tech companies. And in fact, I was on the Digital and Comms Committee in 2020 when I think that was a key plank of our report following that inquiry that we carried out then, prior to the Joint Committee, then looking at this issue of legal but harmful, etc. And I'm really glad that was dropped, because when I asked a civil servant, what do you mean by harmful? He actually, I know I shouldn't be saying this, but he actually replied to say, well, it might upset people. So I mean, it's a very subjective thing. This is really difficult for the government. And, you know, we must do all we can to support the government in terms of trying to find the right solutions. But I do worry that we're sort of trying to make things right. But remember, once it's in an act, and I speak as a lawyer, sorry to say I'm a lawyer, barrister, once it's there, it's there. And people will use that and they'll use it as a tool. I mean, 2002, I was introduced at New Scotland Yard to an incredible site on the internet, How to Be a Good Paedophile. 65 ways to become a good paedophile, right? And where does that fit in this clause 12? I haven't quite worked that out. Is it sex? What is it? You know, we've got to be really careful. I would prefer if we had no list here, but we actually made it sort of more general in a sense, in terms of relying on the system to allow us to opt in, and I do support my noble friend Lady Morgan's amendment on this, to make it easier for people to say, well, that's fine, but it's not excluding people. I mean, what happens if you don't fit this clause 12? Does it mean you just have to suck it up? I don't know. That's not a very House of Lords expression, I know. But I'm sure our noble lords will relate to it. So, my lords, I just rise to say we have to go with care. And I'm going to be saying a little bit more in the next group of amendments on anonymity. Really hard. But what the government's proposing isn't quite there yet.
I just ask the noble lady to say that seemed to be provoked by my saying we must go and look after the vulnerable. But I'm actually suggesting that we use UK law and UK, you know, and the rights that we have already established. And is that not better than having a small list of individual items?
I do agree. I think the small list of individual items, that's the danger. Thank you.
Support the noble Lady Buscombe in pointing out the obsolescence, the built-in obsolescence of any list. It will very, very soon be out of date. I really rise to speak in support of the amendments in the name of the noble Lord Clement-Jones, and indeed those in the name of the noble Lady Baroness Morgan of Cotes. They effectively seek a similar aim. Like Baroness Fraser, I tend towards the ones in the name of Lord Clement-Jones because they do seem clearer and more inclusive, but I do understand they are trying for the same thing. I would also like to register support for this aim of my noble friend Baroness Campbell of Surbiton, who can't be here, but I suspect she is listening in at the moment and was very keen that her name was recorded as supporting this particular aim. The issue of on by default inevitably came up at second reading, and the Minister then, and in subsequent discussions, reiterated that his view that a default on approach to user empowerment tools would negatively impact people's use of these services. Speaking at your Lordship's Communications and Digital Committee, on which I sat at the time, Minister Scully went further and said that having the settings off, the strongest option in the first instance, and I quote, would be an automatic shield against people's ability to explore what they want to explore on the internet. Now, according to the government's own list, this was arguing for the ability to explore content that abuses, targets, or incites hatred against people with protected characteristics, including race and disability. And I really do struggle to understand why protecting this right takes precedence over ensuring that groups of people with protected characteristics are, well, protected. Mm-hmm. That is our responsibility. I would argue that it is precedence, because switching controls one way is not exactly the same as switching them the other. It would be easy to think so, but the noble Lady Baroness Parminter has explained very clearly that it isn't the same. It's undoubtedly easier for someone in good health and without mental or physical disabilities to switch controls off than it is for those with disabilities or vulnerabilities to switch them on. That is self-evident. And it cannot be right that those people who are most at risk of being targeted online, including some disabled people, not all disabled people as we've heard, and those with other protected characteristics, it can't be right that they will have the onus on them to switch on the tools that will prevent them seeing and experiencing harm. And indeed, there's a real risk that those who are meant to benefit from user empowerment tools, those groups who are at higher risk of online harm, which includes people with a learning disability, won't be able to access the tools because the duties allow Category 1 services to design their own user empowerment tools, which means we are likely to see as many versions of user empowerment tools as there are Category 1 services to which this duty applies. And given what we know about the nature of addiction and self-harm, and we have had this very eloquently explained already, it cannot be the intention of this bill, surely, that those people who are in crisis, those people who are vulnerable, for example, to eating disorders or to self-harm, it can't be right that they'll be required to seek and activate a set of tools that turns off the very material that feeds their addiction or encourages their appetite for self-harm. The approach in the bill does little to prevent people spiralling down this rabbit hole towards ever more harmful content. And indeed, instead it requires people to know that they are approaching a crisis point and to have sufficient levels of resilience and rationality to locate the switch and turn on the tools that will protect them. That is not how the irrational or the distressed mind works. And so all the evidence that we have about the existence of harm which arises from mental states, which has been so eloquently set out in introducing the amendments, and I refer again to my noble friend Baroness Parminter, because that is such powerful evidence, all of this tips the balance in favour, I believe, of setting the tools to on by default. And I very much hope the Minister will listen and heed the arguments that we've heard set out by noble lords across the House and come back with some of his own amendments at report stage.
Before the noble Baroness sits down, or a clarification, because I'm genuinely confused. When it comes to political rights for adults in terms of their agency, they are rights which we assume are able to be implemented by everyone, but we recognise that in the adult community, this is offline now, I mean in terms of how we understand political rights, there may well be people who lack capacity or who are vulnerable, and we take that into account. But we don't generally organise political rights and political access to, for example, voting or free speech around the most vulnerable in society. And that's not because we're insensitive or inhumane or don't understand. And the moving testimonies that we've heard about people with eating disorders and so on are absolutely spot on and accurate. But are we suggesting that the world online should be organised around vulnerable adults rather than adults and their political rights?
I don't have all the answers, but I do think we heard a very powerful point from the I'm going to get it wrong too, the noble prelate, thank you. The Right Reverend Prelate, thank you. Thank you, Hansard, for not recording that. We cannot, in doing the same for everybody, we do not ensure equality. We need to have varying approaches in order that everybody has equality of access. And as this bill stands, it says nothing about vulnerable adults. It simply assumes that all adults have full capacity. And I think what these amendments are seeking to do is find a way to recognise that simply thinking about children and then that everybody age 18 is absolutely able to take care of themselves and, if I may, suck it up, that isn't the world we live in. We can surely do better than that.
My Lords, I rise briefly to support the noble Baroness Lady Morgan's Amendment 34 and 35 and others in this essential group. It is not enough to say that the new triple shield will help prevent adults seeing harmful but legal material if they so wish. Having removed harmful but legal from the original bill, there is now a need to ensure that the default options are the safest for users in regard to suicide, self-harm, eating disorders and the abuse and hate content. As the bill stands, adults can still see the most dangerous content online. Young people over 18 may be especially vulnerable if faced with a torrent of images edited digitally to represent unattainable beauty standards. It can result in poor body image, detrimental to mental health, resulting in shame, anxiety, and in some cases suicide. As other noble lords have said, anorexia has the highest mortality rate of any mental health problem. We know pro-anorexia sites are rife online. Vulnerable adults should be protected. These amendments would make a real difference to the bill. Changing the user empowerment provisions to require Category 1 providers to have the safest options as the default for users would be a straightforward way of increasing the protection of most internet users who do not want to have this material bombard them. It would not overburden the tech companies and could do some good. It would not curtail freedom of speech, as tech-savvy users could easily flip a switch if they wish to opt into some of the most dangerous content, which will still be available online, rather than by receiving it by default. Even with the government's best intentions to prevent the encouragement to serious self-harm, we know it cannot criminalise all the legal content that treads the line between glorification and outright encouragement, as Noble Baroness Lady Morgan said. As the Communications and Digital Select Committee, on which I now serve, said in its 2021 report, the online safety bill should require Category 1 platforms to give users a comprehensive toolkit of settings overseen by Ofcom, allowing users to decide what types of content they see and from whom. Platforms should be required to make these tools easy to find and use. The safest setting should always be the default. My Lords, I hope the Government accepts these valuable and simple amendments. They are supported by the Mental Health Foundation, to whom I owe thanks for this briefing, and together with many other experts in the field of mental health.
Lords, this is my first contribution to this bill, and I feel I need to apologise in advance for my lack of knowledge and expertise in this whole field. In her initial remarks, the noble lady Baroness Morgan of Cotes was saying, well, don't worry because you don't need to be a lawyer. Unfortunately, I don't have any expertise in the field of the internet and social media and all of that as well. So I'll be very, very brief in all of my remarks in this bill. But I feel that I can't allow this bill to go past without at least making a few remarks as Equality's spokesperson for the Lib Dems. They're of passionate importance to me and, of course, to victims of online abuse, and it is they that I speak for today. So in this group, I'd like to address my remarks to Amendments 34 and 35, which we have discussed the content which is deemed to be harmful, suicide, self-harm, eating disorders and abuse and hate content under the Triple Shield approach. Although this content discussion has strayed somewhat during the course of the debate. My Lords, much harmful material, as we've heard, initially comes to the user uninvited. I don't pretend to understand how these algorithms work, but my understanding is if you open one, they literally click into action, increasing more and more of this kind of content being fed to you in your feed. The suicide of young Molly Russell is a typical example of the devastating consequences of how much damage these algorithms can contribute. And I'm glad that the bill is going to go farther to protect children, but it still leaves adults, some young and vulnerable, without some protection. With the same amount of automatic exposure to harmful content, which algorithms can increase with engagement, which could have overwhelming impacts on their mental health, as my noble friend, Lady Parminter, has so movingly and eloquently described. So this amendment means a user would have to make an active, conscious choice to be exposed to such content, an opt-out rather than an opt-in. And this has been discussed at length by noble lords a great deal more versed in the subject than I. But surely the only person or organisation who would not support this would be the ones who don't have the vulnerable users that we have been talking about this afternoon, best interests at heart.
And I hope the noble Lord the Minister will confirm in his remarks that the government does.
My Lords, I hadn't actually intended to speak in this debate because I now need to declare an unusual interest in the sense that Amendment 38A has been widely supported outside this chamber by my husband, the Member of Parliament for Weston-super-Mare. I'm not intending to speak on that particular amendment, but nonetheless, just in case. I rise to speak because I've been so moved by the speeches, not least by the Right Reverend Prelate's speech. And I'd like just to briefly address the default on amendments and add my voice of support. Like others, I think on balance I favour the amendments in the name of the noble Lord Clement-Jones, but would willingly throw my support behind my noble friend, Baroness Morgan as well, were that the preferred choice in the chamber. I'd like to simply add 2 additional reasons why I think I would ask my noble friend the Minister to really reflect hard on this debate. The first one is that children become teenagers, become young adults, and it's a gradual transition. Goodness do I feel it as the mother of a 16-year-old and a 17-year-old. And the idea that on one day all of the protections just disappear completely and we require our 18-year-olds to immediately reconfigure their use of all digital tools just doesn't seem a sensible transition to adulthood to me at all. Whereas the ability to then, as you mature, switch off user empowerment tools as you mature as an adult seems a very sensible transition. I think, my Lords, my second argument, I respect very much the free speech arguments that the noble lady Baroness Fox has made, but I don't think this is a debate about the importance of free speech. This is actually a debate about how effective the user empowerment tools are. If the user empowerment tools are so hard for non-vulnerable adults to turn them off, what hope have vulnerable adults to be able to turn them on? So I think the actual onus needs to be, for the triple shield to work, for the 3-legged stool to be effective, is that tech companies need to make these user empowerment tools really easy to turn on and turn off. Then default on isn't a restriction on freedom of speech at all. It is simply a means of protecting our most vulnerable.
My Lords, this has been a very thoughtful and thought-provoking debate this afternoon. And I really would start very much from the point of view expressed by the noble Baroness Kidron. And indeed, I think this brings a noble Baroness Buscombe into agreement on this. It's not about the content. This is about features. This is Clause 12, and I think the noble Baroness Harding made exactly the same point. This is not, and the noble Baroness Healy, this is not about restriction on freedom of speech. This is about a design feature in the bill, which is of crucial importance, my Lords. When I was putting together the amendment that I've tabled, the 2 amendments I've tabled, my Lords, I was very much taken by what Parent Zone, in a recent paper, described. They described user empowerment tools as, quote, a false hope. And they rightly have a number of concerns about undue reliance on tools. They say there is a real danger of users being overwhelmed and bewildered. And they go on to say in that paper, tools cannot do all the work because so many other factors are in play: parental styles, media literacy and technological confidence, different levels of vulnerability and, crucially, trust. So the real question, and this is why I thought that we should look at it from the other side of things in terms of default, the question is how we mandate the use of these user empowerment tools for both children and adults in the bill. So in a sense, my concerns are exactly the opposite of the noble Baroness Fox's, for some strange, unaccountable reason. But, my Lords, the noble Baroness Morgan, the noble Lord Griffiths, the Right Reverend Prelate, and notably my noble friend, Baroness Parminter, have made a brilliant case for their amendment, my lords, and I think it's notable that these amendments are supported by a massive range of organisations, my lords, all in this area of vulnerable adults. The Mental Health Foundation, Mind, the Eating Disorder Charity, BEAT, the Royal College of Psychiatrists, the British Psychological Society, Rethink Mental Illness, Mental Health UK, and so on, my lords. Now, this isn't a coincidence that all these organisations are discussing this, quotes, feature, my lords. This is an absolutely crucial aspect of the bill. And again, I was very much taken by some of the descriptions that were used by noble lords during the debate. As the Right Reverend Prelate, the Bishop of Oxford, said, young people don't suddenly become impervious to content when they reach 18, particularly the pressures that he described as the use of AI only increases, my lords. And I thought that noble Baroness Harding, in the way she described the progression from teenagehood to adulthood, my lords, was extremely important. There isn't some sort of point where somebody suddenly reaches the age of 18 and they then have full adulthood, my lords, which enables them to deal with all this content. Under the bill as it stands, adult users could still see and be served some of the most dangerous content online. And as we've heard, this includes pro-suicide, pro-anexia and pro-bulimia content. And my lords, one only has to listen to what my noble friend Baroness Parminter had to say to really be affected by the operation, if you like, of social media in those circumstances. This is all about the vulnerable, my lords. And of course, we know that anorexia has the highest mortality rate of any mental health problem. The NHS is struggling to provide specialist treatment to those who need it. Meanwhile, suicide and self-harm related content remains common and is repeatedly implicated in deaths. And my lords, all members here who were members of the Joint Committee remember the evidence of Ian Russell about his daughter Molly. I think that affected us all to a huge extent. So we do believe now you can pay your money, take your choice, whichever amendment seems appropriate, but changing the user empowerment provisions to require Category 1 providers to have either the safest options as default for users or the terms of my two amendments, my lords, are surely a straightforward way of protecting the vast majority of internet users who don't want to have this material served to them, my lords. Now, you could argue that a new offence on encouragement to serious self-harm, which the government has committed to introducing, might form part of the solution here, but you can't criminalise all the legal content that treads the line between glorification and outright encouragement, my lords. And, of course, we know the way the bill has been changed. And so no similar power is proposed, for instance, to address eating disorder content, my lords. The noble Baroness Healy quoted our own Communications and Digital Committee in the recommendation they made about a comprehensive toolkit of settings overseen by Ofcom, allowing users to decide what types of content they see and from whom. But at the end of the I'm very supportive of the amendment from the noble Lord Knight, 38A, which gives a greater degree of granularity about the kind of user, in a sense, that can communicate to users, my lords. Modesty means that, of course, I prefer my own amendments, my lords, and I do agree with the noble Baroness Fraser, Baroness Bull and noble Baroness Harding, and I'm very grateful for their support. But the fact is that we're all heading in the same direction, my lords. We are all arguing for a broader by default approach. The onus shouldn't be on these vulnerable adults in particular to switch them on, as the noble Baroness Bull said. It is all about those vulnerable adults, and we must, as my noble friend Baroness Burt said, we must have their best interests at heart, and that's why we've tabled these amendments, my lords.